The topic taken for discussion is Judicial Review of Administrative Discretion. So, இன்று எடுத்துக்கொள்ள இருக்கின்ற தலைப்பு அட்மினிஸ்ட்ரேட்டிவ் டிஸ்கிரிஷன், அதாவது ஒரு நிர்வாகத்தினுடைய அவர்கள் எடுக்கின்ற பவரை பற்றியும் அவர்கள் அந்த பவரை துஷ்பிரயோகம் பண்ணும்பொழுது அதற்காக நீதிமன்றத்தில் ரெவ்யூ, ஜுடிஷியல் ரெவ்யூ என்பதை பற்றி பார்க்க இருக்கின்றோம். ஸோ இதை பற்றி ஒரு சேயிங், மேக்னா கார்ட்டா சேயிங், we will not make jurists, constable, sheriffs or bailiffs who do not know the law of land and mean to observe it well என்று கூறுகின்றது. இந்த சேயிங்கே இந்த தலைப்பை விளக்கின்றது. அதாவது சட்டம் தெரியாத அதாவது லா ஆஃப் லேண்ட் தெரியாத ஜட்ஜோ அல்லது கான்ஸ்டபிளோ ஷெரீஃபோ தேவையில்லை. we will not make justice. நாங்கள் அவர்கள் எங்களுக்கு தேவையில்லை. அதோடு அல்லாமல் அதனை பயன்படுத்த வேண்டும் அண்ட் மீன் டு அப்சர்வ் இட் வெல் என்று சொல்லுகிறது. ஸோ ஜுடிஷியல் ரிவ்யூ என்பது, அட்மினிஸ்ட்ரேட்டிவ் டிஸ்கிரிஷன் என்பது என்னவென்றால், ஸோ தி அத்தாரிட்டிஸ் ஆர் கிவன் பவர் to exercise for the welfare of the people, but when it is not, when they fail to use their discretionary power, or when they use their power more than what they have to do, then it is detrimental to the welfare of the people. That should not be. When such is the case, the judicial review will take up its own course. பொதுவாக in general the administrative discretions will not be questioned by the judiciary, but in the case where it is required, where they flout the norms or where they exceed their limit, or where they fail to exercise the discretion, or when the infringement of fundamental rights are there, then the judicial review will take up. Today we may be knowing that the state has to do lot of functions, being the welfare state. Previously the state was under the term called laissez-faire state. That means anybody can do any activities. It is a free government. Then it has been converted to police state, and now it has been converted as welfare state. In welfare state, by leaps and bounds, they have to do lot of welfare activities. For that, for the betterment of the society, they have to use their discretionary powers in proper manner. That we are going to discuss it. When there are two types of administrative discretions. One is called the maintenance of registers, that is the birth and death register and other statistical data. So these are all the routine things that the administration is doing. And the second thing is they have to do that the fundamental rights or the human rights are adhered properly. That is also the second thing. That is in the case of detention matters and in the case of inquiry, trial and investigation procedures, the proper procedures are to be followed, so that the human rights are not violated or the rights of the human beings are not infringed. That is the main concern of this the judicial review. So naturally the judiciary will not interfere in the administrative discretion matters, but when it is required, they interfere in the matter of administrative discretion. The court interferes in the administrative matters. Now they have their own testability. They have the judiciary has its own testability and other things. So they will clip the administration in case if they are not doing properly. That is the thing we want to discuss here. So under the three headings we are going to discuss the judicial review. One is called failure to exercise discretion, and another is excess or abuse of discretion. Third thing, infringement of fundamental rights. The failure to exercise discretion என்றால் அவர்கள் அட்மினிஸ்ட்ரேட்டிவ் அத்தாரிட்டிஸ், அது யூனிவர்சிட்டி ஆகட்டும் அல்லது டிரான்ஸ்போர்ட் அத்தாரிட்டி ஆகட்டும் அல்லது ஒரு கலெக்டர் ஆகட்டும் அல்லது ஆர்டிஓ ஆர் தாசில்தார், இவர்களெல்லாம் அட்மினிஸ்ட்ரேட்டிவ் அத்தாரிட்டிஸ். அவர்களுக்கென்று ஒரு பிரத்யேகமாக அவர்கள் அந்த அவருடைய பவரை பயன்படுத்தலாம். அதனை பயன்படுத்தவில்லை என்றால் தென் இட் இஸ் கால்டு ஃபெயிலியர் டு எக்ஸர்சைஸ் டிஸ்கிரிஷன் என்று பேர். இதனில் 4 தலைப்பு வருகிறது. ஒன்று, சப் டெலிகேஷன். யூஸ்வலி த டெலிகேஷன் மீன்ஸ் த லா மேக்கிங் பவர் is given to executives. Usually it is done by legislature, but under extraordinary circumstances or when the time is not there, the legislature giving power, the law making power to the executives. That is called delegated legislation. And the irony of the another thing is the delegation, the executives further delegate their power. That is called sub delegation. And this is sometimes this works very well, but when it is not working very well, that is null and void. The delegation, sub delegation is null and void. That is in the case of Allingam versus Minister for Agriculture, the sub delegation is termed as null and void. Then second thing, the imposition of imposing factors on discretion by self imposed rules or policy. That is, some authorities, discretion authorities, the higher authorities who can exercise their power, they sometimes take their law in their own hands and they themselves giving certain orders which is detrimental to the community or detrimental to the people. That is the case study we will be seeing. Kesavan Bhaskaran versus State of Kerala. What happened in this case? The student who is leaving secondary school leaving certificate has to complete 15 years of age, but he arbitrarily, that the director of school education arbitrarily gave an order stating that within, if the relaxation is asked within 2 years of age, then the secondary school leaving certificate can be given. But in the present case, this is just well below the 13 years of age. So it was refused to give the secondary school leaving certificate. Then it was contended, and what the decision taken by the director of school education was bad, because there is no such discretionary power, there is no such order he can give to the authorities. So he has not used the discretionary powers properly. This is the imposing factors. தலையை அவரே ஒரு ஆர்டரை கொடுத்து, இந்த 2 வருடம் தான் நம் அந்த ரிலாக்ஸேஷன் கொடுக்கலாம், 2 வருடத்துக்கு கீழே இருந்தால் கொடுக்க முடியாது, 15 வயசு என்பது 13 வயசாக இருந்தால் கொடுக்கலாம் என்று, 13 வயசுக்கு மேலாக இருந்தால் கொடுக்கலாம் என்று, இந்த 13 வயசுக்கு கொஞ்சம் கீழே இருக்கிறதால கொடுக்க முடியாது என்று சொன்னதால் இது வந்து டிஸ்கிரிஷன் பவரில் தவறு என்று நிரூபிக்கப்பட்டது. Third thing is acting under dictation. That is, in this case, what happened in this case, that is, the authorities will be there, the higher authorities, if they dictate, then they will reverse their original order or original standing, or what they have to use their power, that they will that will be tumbled down. And this is bad on the part of the administrative authorities. What happened in this case? Bombay Police Act 96, the Bombay Police Act applicable in 96 is applicable in this case. What usually the Commissioner of Police is empowered to give permission for the construction of cinema theatre as well as running of cinema theatre. So accordingly, the permission was granted already, but all of a sudden, due to the interference of the state, the order was withdrawn, and this was stated by the court that it is null and void, or it was held invalid. that is acting under dictation. Then the last thing, non-application of mind, that is in this case what happened, the preventive detention, actually the higher authority should apply their mind irrespective of the force behind it, behind an action. So what happened in this case, that is the preventive detention was cancelled by the Home Secretary on the advice of the police or on the recommendation of the police. Home Secretary not applied is in this case. What happened in this case? So the preventive order was already ordered, and that was cancelled by Home Secretary on the advice of the police or on the recommendation of the police. Home Secretary not applied his mind. Actually the repeal of that order should not have been done. That is against the discretionary power. These are all coming under the failure to exercise discretion. ஆகவே ஒரு இதில் நான் ஃபெயிலியர் டு டிஸ்கிரிஷனில் என்னவென்றால் மைண்டை அப்ளை செய்ய வேண்டும். ஆக்டிங் வேறொரு ஹையர் அத்தாரிட்டி சொல்வதால் இவர்கள் எதுவும் செய்யக்கூடாது. அதோடு அல்லாமல் ஒரு அதிகாரியானவர் அவரே ஒரு ஆர்டர் கொடுத்து ஒரு புது ஒரு முன்மாதிரியை உண்டாகக்கூடாது. அப்புறம் சப்டெலிகேஷன் செய்யக்கூடாது என்பதே இதில் வருகின்றது. அடுத்ததாக எக்ஸஸ் ஆர் அப்யூஸ் ஆஃப் டிஸ்கிரிஷன். எக்ஸஸ் ஆர் அப்யூஸ் ஆஃப் டிஸ்கிரிஷன் என்றால் அவர்களுக்கென்று சில பவர்கள் கொடுத்துருக்கப்பட்டிருக்குது அட்மினிஸ்ட்ரேட்டிவ் அத்தாரிட்டிஸ்க்கு. அவர்கள் அதை மீறி, ஃபார் எக்ஸாம்பிள், எ பர்சன் கேன் sanction 2000 rupees ஃபார் டவுன் ட்ராடன், say for example. Suppose if he sanctions more than that limit, say 3000 or 4000, it is excess or abuse of discretion. This type of discretion should not be there. That is, in this some 9 points are coming. We will see one by one. Exceeding jurisdiction, that is the jurisdiction is already given there, they should not exceed their jurisdiction. That is, the case study is Ces Corporation versus Workers Union. What happened in this case? The workers union are covered under medical scheme. The family cannot utilize the medical scheme, but in this case the medical scheme was granted to the family members of that corporation, workers union, so that it was held as null and void, or it is excess of jurisdiction, discretion. And then second thing, irrelevant consideration. Sometimes what the irrelevant consideration means, தேவையற்ற ஒன்று, அதாவது பொருத்தமில்லாதவற்றை அதை எடுத்துக்கொள்ளுதல், that is irrelevant consideration. In this case actually the case study is PL Arora versus state of UP. What happened in this case? Usually the state can acquire land for the public purpose, and that it can be given to some company if it is satisfied that it is for the public purpose or public use or for public welfare. So what happened in this case, the textile company have to be started. For that then land acquired by the Act 1894. Actually the state government need not have gone for the Land Acquisition Act, because the consideration was irrelevant. Actually it need not be, it is felt that it is not for public purpose, that's why it is considered as irrelevant. Then coming to the third point, leaving out relevant consideration. In some of the cases the relevant thing is not considered at all. That is, in this case Rampur District Company versus Company Law. What happened in this case? That is, the Company Law Board have not renewed the actually have not renewed the company, and then this was considered as bad on the part of that is the company law board. Then next thing is mixed consideration. Mixed consideration, there are two things are to be considered in mixed consideration. One is called conclusion based on satisfaction, that is subjective satisfaction, and then another thing conclusion based on objective facts. So whenever certain decisions are taken or whenever some discretion are to be imposed, there should not be mixed consideration. It should not be on subjective satisfaction. The subjective satisfaction means it is purely on the satisfaction of the individual for their satisfaction. That should not be in the case of the discretionary powers. That is one thing. Another thing, the conclusion based on objective facts, this is allowed because the objective facts is always as a wide range of thing, and this is not bad or this is for the welfare of the society. So whenever the mixed consideration is there, the conclusion based on subjective satisfaction is quite wrong. For that, the case study is Zora Singh versus team Tondon. Set aside the order of detention. In this case, this detention order was set aside. Actually, a person has to be detained, and that was set aside in this case because the mixed consideration was taken, and particularly the objective facts were not taken in this case. And then the next thing is mala-fide. Mala-fide means some bad intention on the part of the administrative authorities to satisfy that bad intention, or to satisfy for their own affairs, or it may be for their kith and kin, or for it may be for some other purpose. If the inner intention may be mala-fide, that is called in this case the case study is Municipal Council versus Campbell. What happened in this case, they wanted to widen the road, for which the compensation has to be given and all for the widening of the road, but the very purpose of widening of the road and other thing was with the ulterior motive of giving some extra benefit to some people, that was the inner intention. So this was bad on the part of the administrative authorities, and that's why it was set aside, because the intention was mala-fide. The next thing is improper purpose or collateral purpose. What happened in this case, sometimes what they do, the purpose is somewhat improper. Actually for something they will sanction, but the purpose is something different. In the particular case of this improper purpose, collateral purpose, what happened, the Nalini Mohan versus district magistrate case, what happened in this case, the rehabilitation was ordered for the people who are repatriated from Pakistan. That is always there, but what happened in this particular case, to accommodate a person who was on medical leave and came to India, for that person this order was given, that is the some rehabilitation measures was given to that person. That was very bad on the part of the administration, because the purpose of rehabilitation is improper purpose. Next thing is colorable legislation. Exercise of power ostensibly used, but for different purpose. Actually for the what for the purpose is for the purpose sanctioned, that should be fulfilled, but for different purpose, if they are if the discretionary powers are used, that is called colorable exercise of power, and this is also wrong on the part of the administrative authorities. And then disregard of the principle of natural justice. Usually what should be adopted is while taking decision, some of the principle natural justice, that is hearing, that is giving notice, hear the other side, and one should not be the judge of his own. All these things should be adopted and if that is not adopted, that is also bad on the part of administrative discretion. So this is with regard to the disregard of the principle of natural justice. Then next thing is unreasonableness. What happened in this case? Actually, CS Rotak versus Industries Limited. The case study is Rotak Industries Limited versus SD Agarwal. According to the Company Act 1956, the inquiry was ordered by the government, and since there was no fraud committed, the inquiry was not needed. It was decided like that, and that is called unreasonableness. So by these things, the one may abuse or the excess of discretion will be there. In that 9 topics or 9 subtopics are there. இதில் என்னவென்றால் அதிகாரத்தில் இருப்பவர்கள் அவர்களுடைய அதிகாரத்தை துஷ்பிரயோகம் செய்ய, அதாவது அவர்களுக்கு கொடுக்கப்பட்டிருக்கின்றதுக்கு மேலாக அவர்கள் அதனை பயன்படுத்தக்கூடாது என்பதற்காக இந்த 9 சப்டாபிக் வருகிறது. அதாவது அவங்களுடைய எல்லையை மீறுதல், irrelevant consideration, தேவைப்படாததை அவர்கள் அதை செய்தல், அப்புறம் தேவைப்படுவனற்றை விட்டுவிடுதல், அப்போ மிக்சட் கன்சிடரேஷன் என்று சொல்லப்படுவது, அப்புறம் களங்கம் கற்பிக்கக்கூடியதாக இருப்பது, அப்போ தேவைப்படுகிறதுக்கு அல்லாமல் செய்வது, அப்புறம் தென் கலரபிள் எக்ஸைஸ் என்று சொல்லப்படுவது, தென் பிரின்சிபல் ஆஃப் நேச்சுரல் ஜஸ்டிஸ், இயற்கை விதிகளுக்கு நீதிக்கு மாறாக நடத்தல், காரணம் இல்லாமல் ஒரு ஆக்ஷன் எடுத்தல் போன்றவை எல்லாம் எக்ஸஸ் ஆர் அபியூஸ் ஆஃப் டிஸ்கிரிஷனில் வருகிறது. The next thing is infringement of fundamental rights. That means the fundamental rights are to be adhered by any means. From Article 12 to 32, that is Constitutional Law, Article 12 to 32 says clearly about the fundamental rights. Particularly the golden articles such as Article 14, 19 and 21 are to be strictly adhered by the administrative authorities. What the Article 14 says, equality, all are equal, and no discrimination should be shown among the community, among the society. That is Article 14. Article 19, that is freedom of 6 freedoms are there: freedom of speech, freedom of occupation, freedom of working from one place to another place, and freedom to property. So many things are there in 19. And Article 21, freedom to life and liberty. This is very, very important. For this we can quote one case study, that is Maneka Gandhi versus Union of India. What happened in this case? The passport was given to Maneka Gandhi, and she applied for tour to abroad, tour to foreign countries, but all of a sudden abruptly it was the permission was not granted, and as such Maneka Gandhi has to seek the court of justice, and in that it has been stated that she has not been given the principle of natural justice has not been followed. The reason has not been told. The reason told is it is for the public security, public for the public purpose, like that. It was the only thing they have told. So this is against the fundamental rights. This is infringement of fundamental rights, and so that was set aside. So by this way, the judicial review and administrative discretion is followed in India with proper the synchronization or for the coordination between the administration and the judiciary. Actually, judiciary should not interfere in the matter of administration, but in extraordinary circumstances, when there is no other go to impose certain the welfare to the people, or if the infringement of the fundamental right or the discretion official discretion, then necessarily they have to interfere, and that is called the judicial review. With this we conclude the judicial review and administrative discretion, because now with lot of welfare activities have to be done, and we the people entirely depend upon the administration, and that the administration has to deal the things properly or execute the welfare measures to the people properly without any bias, without any flouting of norms. That is the inner meaning behind it. With this we conclude this topic.